Hi everyone and welcome to another episode of the series that I call the Case Files. Today we'll be discussing the famous case of the Harvard Oncomouse. It deals with the issue of whether a living creature can be patented and owned by another person or an organization. What is interesting is that different countries came to different conclusions. Let's discuss. Before we get into the nitty-gritties of the Harvard Oncomouse case, let's quickly discuss what intellectual property is. Intellectual property, or IP, refers to the legal rights that are granted to individuals or organizations over their creations or inventions. It includes several areas including trademarks, copyrights, industrial designs, patents, etc. If you're interested in learning about the different types of IP, check out my video on it. I'll put a link to it in the description below. Now, patents in particular are exclusive rights granted to the inventors for a period of 20 years, allowing them to exclude anybody else from making, using, and selling their invention. These patents incentivize innovation and protect the interests of inventors. Now let's dig into the Harvard Oncomouse case and why it's a landmark judgment in intellectual property law. The Harvard Oncomouse is a genetically engineered mouse, what we call a transgenic animal, whose DNA had been altered by the scientists at Harvard University. This unique mouse was created with the onco or cancer gene to make it susceptible to cancer, making it a valuable tool for studying the disease and testing potential treatments. However, the question was whether a patent should be granted for this invented mouse to the Harvard University. Different countries considered this question. The Harvard University filed a patent application for the Oncomouse at the USPTO, that is, the United States Patent and Trademark Office, seeking to protect their invention and to secure exclusive rights to its usage. In 1988, the USPTO granted the patent in favor of the Harvard University, stating that living, non-human, genetically altered organisms could in fact be patented. The patentability of the Harvard Oncomouse was also considered by the European Patent Office, or the EPO. They looked at two issues when considering whether the mouse was patentable. Number one, non-patentability of animal varieties, and number two, whether it would be contrary to public morality to grant this patent. The EPO overcame the first issue by concluding that the Harvard Oncomouse did not qualify as an animal variety. This made sense since the mouse was not a creature that existed naturally in nature. In considering the second issue, the EPO adopted a utilitarian test. Simply put, the utilitarian model will weigh the positives against the negatives of an action, and if the positives outweigh the negatives, then the utilitarian model will endorse that action. They found the benefits to humanity from the Harvard Oncomouse, especially the usefulness of this mouse to cancer research, outweighed the negatives, which was the suffering of the mouse. And therefore, the EPO also allowed the patenting of the mouse. The patent was also applied in Canada, and this issue went all the way up to the Canadian Supreme Court in the case of Harvard College versus Canada. The Canadian Supreme Court in 2002 concluded that higher life forms cannot be patentable because they do not qualify as a manufacture or a composition of matter, as required for by the definition in the Canadian law. They also were of the view that the Parliament should debate on this, considering the moral and social issues, and create new laws on how to deal with these issues. The Oncomouse case highlights how different jurisdictions have dealt with the question of whether transgenic animals should be patentable or not, and how they have weighed the ethical dimensions versus the advancements of technology. In one sense, the decisions from the United States and the EU mark a significant milestone for intellectual property law, broadening the scope of what can be patentable to include some types of living organisms. These decisions show the importance of protecting and encouraging innovation in the rapidly advancing field of biotechnology. On the other hand, the decision from Canada highlights the complex ethical and social considerations surrounding intellectual property law in the biotechnology sector. It also creates the question of whether a person or a body should be allowed to own a living organism. Unfortunately, there still doesn't seem to be a balance identified between the need to encourage innovation and the ethical concerns over patenting a living organism. In conclusion, the Harvard Oncomouse case has had a significant impact in our society. It has paved the way for the patenting of genetically enhanced animals, thus encouraging the ongoing efforts to find a cure for illnesses like cancer. However, it has also raised concerns regarding the suffering of animals during this research. Anyway, what do you think? Do you think transgenic animals should be patentable? Let me know in the comments below. Also, don't forget to like the video and subscribe to the channel. I'll see you in another episode. Take care. Bye.